The examples of the immunities, the most well-developed and the well-defined area of the immunity is that the diplomatic immunities. Centuries of the state practice with diplomatic relations have produced considerable precision as to the rules. The law is new codified in the Vienna Convention on the Diplomatic Relation 1961. While serving in a host country, diplomatic agents enjoy personal immunity. They are immune from criminal jurisdiction. Their person is inviolable and they may not be arrested or detained. Diplomats also enjoy immunity in third states while in transit between their sending state and host state. After their term of service in the host country has ended, diplomats continue to enjoy functional immunity for acts in the exercise of their function. If the diplomat commits a serious crime, the recourse available to the host state is to request a waiver of immunity from the sending state or to declare the diplomat persona non grata. After the diplomat term is over and after a reasonable time for departure has elapsed, the diplomat enjoys only functional immunity, and thus the host authorities may prosecute the diplomat for any crimes committed in non-official capacity. If they can acquire custody of him or her, other members of the diplomat mission enjoy lesser degree of immunity as do consular officials. The contours of the head of state immunity are less well defined. There is no codifying convention and state practice on point is limited. The lack of state practice is probably in part of the reflection of the immunity and in part due to reluctance of states to interfere with the head of state. Even the conceptual foundation of the immunity are unclear. It is widely accepted, however, the head of state enjoy at least the same immunities as ambassadors, absolute personal immunity while in office, and afterwards functional immunity for official acts carried out while in office. While head of state immunity is well established, the position of the head of government and other minister has not always been so clear. In DRC versus Belgium, the International Court of Justice upheld personal immunity for the ministers of the foreign affairs analogous to that of the head of state. This conclusion is understandable in that the post fulfills similar representative roles. Similar principles undoubtedly apply to the head of government, such as a prime minister whose representative function is more sensitive than a minister of the foreign affairs. And in many systems, the head of state, as will be discussed, section 21, paragraph 4, class 2, it is unclear whether other ministers enjoy this immunity as. Next topic is on functional immunity and national courts. The question of the immunities in respect of the prosecution of international crimes may arise before the national courts in different ways. A state may wish to prosecute a current or former officer of another state, may wish to request extradition, or may receive a request for extradition. The traditionally national governments and courts were so cautious and differential in the area of immunities that controversial efforts at prosecution simply did not arise. In recent times, this has begun to change. Uh, The Pinochet precedent, the case in 1998, Senator Augusto Pinochet, former head of state Chile, was visiting UK when Spain issued a request for his extradition. The charges included torture and conspiracy to torture. Pinochet was arrested by the British authorities. He applied to have the warrants quashed inter alia on the ground that as a former head of state he was entitled to immunity. In the first hearing of the immunity issue at the level of the divisional court, three judges applying a classically differential approach to immunities um, unanimously upheld Senator Pinochet's claim and quashed the warrant. The court applied the established proposition that a formal head of state ceases to enjoy any immunity in respect of the personal private acts, but continues to enjoy immunity in respect of the public acts performed by him as a head of state. Since Pinochet was charged not with the personally torturing or murdering victims or causing their disappearances, but with using the power of the state of which he was head to that end. The judges concluded that they could hardly be described as a private acts and therefore had to be official acts. They rejected the argument that serious international crimes could not be function of the head of state. Immunity from criminal jurisdiction must include criminal conduct, as such immunity would otherwise be entirely pointless. The Nuremberg Charter, ISTY statute and ISTR statute were distinguished on the ground that these were international tribunals established by the international agreements. They did not therefore violate the principle that one sovereign state will not imply another in relation to its sovereign acts. At the first House of Lords hearing, following intervention of the amicus curiae and more detailed review of the developments in international law, 3 out of 5 judges were persuaded that formal head of state immunity did not cover such serious international crimes. The essence of the decision was that commission of the certain serious international crimes, contrary to jus cogens, is condemned by the all state as illegal and therefore cannot also be protected by the international law as official function. The scope of the exception to the functional immunities. A considerable body of international cases, national cases, other state practice and academic commentary support the view that functional immunity does not preclude prosecution for serious international crimes, which is consistent with the broader reading of the Pinochet. However, as well as discussed in this section, the failure of the ICJ to mention the principle as well as few outlying cases means that the proposition is not free from doubt. The authorities indicating no functional immunities for core crimes. As the Nuremberg judgment observed, the principle of the international law, which under certain circumstances protects the representative of the state, cannot be applied to acts which are condemned as a criminal by the international law. The author of these acts cannot shelter themselves behind their official position in order to be freed from punishment. Individuals have duties which uh, transit the national obligation of the obedience imposed by the individual state. He who violates the laws of the war cannot obtain immunity while acting in the pursuance of the authority of the state. If the state in authorizing action moves outside its competence under the international law. The legal theory underlying this proposition is compelling. First, functional immunity protects the state conduct from scrutiny, but it would be incongruous for international law to protect the very conduct which it criminalizes and for which it imposed duties to prosecute. Second, the state cannot complain that its sovereignty is being restricted or that a policy is being imposed on it when the prohibited conduct is recognized by all as international crime. Third, from the perspective of the perpetrator, state agents are normally able to pass responsibility for dubious activities to the state and authorize them. But in the case of the serious international crime, individuals have international duties which transit the national obligation of the obedience, and hence they are rightly held account. Finally, it is also sound in terms of balancing the underlying values. Where individual possess only functional immunity, international law already reflects that such an individual is no longer playing a high representative role, which is necessitate absolute impunity. The proposition was endorsed by the International Law Commission (ILC) and General Assembly as a principle theory of the Nuremberg Principle and has subsequently been reconfirmed by the International Law Commission. The principle was applied subsequent national case in Ichman. Israeli Supreme Court rejected the plea of the Ichman that he was carrying out official activities and held that there is no basis for the doctrine when the matter pertains to acts prohibited by law of nations, especially when they are international crimes of the class of the crimes against humanity. More recently, most in a Botras, the Amsterdam Court of the Appeal had, with respect to the former head of state, Suriname, that serious international crimes such as crimes against humanity did not constitute official function for the purpose of functional immunity. A Belgian court in a Sharon case, Spanish authorities requesting extradition of Pinochet, and a Spanish court in a Castro case all indicted that there was no functional immunity for serious crimes, as did a committee of jurists appointed by the African Unity recommending prosecution of the Hassan Habre, former head of state of the chart. The proposition has also been supported by the International Criminal Tribunal, for example, in Blaskik. The ISTY recognized functional immunity as well as established rule of the customary international law, with the exception that those responsible for war crimes, crimes against humanity, and genocide cannot invoke immunity from national or international jurisdiction, even if they perpetrated such crimes while acting in their official capacity. So it was the functional immunity and national courts, but now the functional community international court. The reasoning in the foregoing authorities is based on the nature of the functional immunity and not on the nature of the jurisdiction trying the crime. Thus, the same reasoning would apply in any forum, including international courts. So it was the functional immunity and the national and international courts, and we have discussed certain case. Now the uh, personal immunity in the national or international courts, which will also discuss the cases which I have earlier mentioned. There's another case, the ISG Yerodia decision in April 2000. A Belgian judge issued an international arrest warrant against the Abdoulaye Yerodia Nendos Dimodesi, who was at the time serving as the Minister for Foreign Affairs for the DRC, Democratic Republic of Congo. The DRC brought the matter to ICJ, arguing that Belgium had failed to recognize the immunity of the serving Minister of the Foreign Affairs. The ICJ held that the 13 votes to 3 that Belgium had breached its international legal duties to the DRC is that they failed to respect the immunity from criminal jurisdiction and the inviolability which the incumbent Minister for Foreign Affairs of the DRC enjoyed under international law. The personal immunity enjoyed by the foreign minister could not be set aside by the national courts by charging him or her with war crimes and crime against humanity. The ICJ examined the non-immunity provisions and Nuremberg Charter and Statute of the ISTY, ISTR, and ICC, and found that these did not suggest any exception in a customary international law in regard to the national courts. The judgment emphasized that the temporary status of the personal immunity did not mean impunity. For serious crimes, first person may be tried in their home courts. Second, they may be prosecuted if the state waives the immunity. Third, they may be prosecuted once they cease to hold office for crimes committed in private capacity. And fourth, they may be prosecuted before the international criminal courts where such courts have jurisdiction. The outcome of the decision is consistent with the line of the national decision and state practice upholding absolute personal immunity. Therefore, there are elements of the decision which have been questioned, first by the observing that former high official may be tried for private acts once they cease to hold office. The ISCJ seems to omit the exceptions that serious international crimes may also be prosecuted. Second, in the view of some commentators, it unjustifiably extended head of state immunity to what may be wide range of ministers without sufficient argument or reference to the authority. Third, ICJ asserted that such ministers enjoy personal immunity even when a private visits without a demonstration that state practice supports such a view. So, students, keeping in uh, keeping in a mind on the view of the various cases of ICJ, ICC, and in national or international courts regarding the immunity. What we have discussed, immunity regarding the acts which done in order to state responsibility or act done in order to a personal capacity. So there are two immunities, functional or personal immunity. They are principled in the light of the decisions we have discussed in thoroughly. I hope you have understand the view of the immunity and defenses regarding the liability and responsibility of the any act which is prohibited under the international criminal law. Uh, I hope you have understand. If you have still any ambiguity, what cases I have referred, and during my lecture, I suggest you you may study those cases at after this class. So thereafter you will understand and you will cover these topics. So now I'm going to end my class. I am going to end my this journey by this lecture. I hope this journey was very helpful in order to understand the international criminal law and its codes, its statutes, and its mechanism. Thank you very much.